If you want to know, one less than 1,000. So if you want to eat,
Hello? Hello? Hello?
Hello, good morning, sir.
Hello? Hello?
Hello, good morning, sir. Hello, good morning, sir.
Hello?
Good morning, sir.
Good morning, sir.
Good morning, sir. Good morning, sir.
Good morning, sir.
Hello? Good morning, sir. Where is Precious? Hello? Have I lost you again? Can you hear me?
We can hear you, sir.
We can hear you, sir.
Okay. I need somebody to be telling me, so I don't know. I was asked to come in today to stand in from Prof. So tell me, where are you with Prof? Hello?
Sir, Prof started teaching us personal income tax, and he stopped that.
Okay.
And he stopped that the
This is,
highlights of pizza are amended.
okay, I forgot your name. What's your name again?
Oyinkansola.
Onyikon. Yes, Onyikon. All right. So, yes. So we're there. And then, do you still have the materials I gave you?
Yes, sir.
Onyikon?
Yes, sir.
I said, do you still have the materials that I gave you?
Yes, I have the materials.
I can't hear you.
Yes, sir, I have the materials.
Okay, is it my network or your network?
Maybe it's your network, sir.
It's my own network.
Yes, sir.
Okay. Are you there?
Yes, sir.
Yes, sir.
Okay. Sorry. I don't know why I got logged off, and I was trying to log in, and every time I'm closing by, the laptop, your captain kept on calling. So tell me, where did you stop the last time?
Sir, do you mean in your class or for the prof?
Yeah, in my class now, in my own
In your
class.
class, we stopped at section 20 of PITA. You said when you continue, you explain the rent test.
Oh, wait, okay. I sent you the material on rent test, didn't I?
No, sir, you haven't.
I sent you the materials on rent test now. Where's the class captain? What do you mean I have not? Is the class captain there?
It's on the group chat. When you call, just check. I'll tag it on.
Okay. So do you have the class captain? Mr. Farumbi?
Yes, sir, I do.
Okay, then read it for us. Any other person?
So I have it now.
Who is that?
When you come.
Who's it? Okay. So before I was told to hand over to Professor Sonny, we are on section 20. 20 deals with deductible expenses. For example, I was given the, let's assume when you come in her where she sells snacks, Coca-Cola, Sprite, and all those things. So let's assume that a month she purchases pure water, 500,000, Coca-Cola and all those things, 500,000. She has employees there. She pays them salary, electricity, another 500,000. That's 2.5 million. Then
then it's really
All right. Can you hear me?
Yes, sir.
I'm very sorry. I keep going off. I don't know what's wrong with the. We are giving an example of what amounts to deductible expenses. So we said if a person in a kiosk opposite Morimi sells Coca-Cola or Pop and all, 6 million naira profit, gross profit. We are going to deduct the expenses. For example, the cost of rent, electricity,
Can't hear you, sir.
I'm so sorry. The network is very bad. Yeah, I don't know what's happening today. Apologize. Just at 9:30, I was told to come in. Very, very bad. So let me see if I can make my argument again. I am trying. So it is not all the profit that the person makes that the person will pay tax on. The expenses incurred while making the profit. The rent, the salaries to the employees, transportation, everything, the cost of refrigerator for storing it. So it is maybe about 3 million of the gross profit, which is 6 million. So the rent, the transportation, fuel, generator, those are expenses. The taxpayer will deduct those expenses. We now arrive at the taxable profit. Okay, so we are going to deduct the cost of yam flour, elubo, cost of tomato, grinding. Those employees will deduct their salaries and everything. It is the profit that is remaining that will be subject to tax. So section 20 now says that for us to determine what kind of expenses that can be deducted, the expenses has to meet the rent test, which is reasonable, exclusive. Every expense. Let's say you are a lawyer. The taxpayer is a lawyer. He's using his house, he's living upstairs, and he's using it downstairs for law office. The same generator is powering the house and powering the law, everything, because not all the fuel for generator is going for the office. Or if a person has stuff at the court, a lawyer has a driver that takes him to court, when he wants to file materials and all that. At the same time, that driver is taking his wife and his children to school and to the market. So it is not everything, all the salary that are paid to the salary that will be deducted. Personal for business. So section 20 now says that it's only those expenses that are only LOI, wholly, reasonably necessary and exclusively. For example, if a lawyer is making 5 million naira a month,
Sir, we can't hear you.
I'm sorry again. So we now said it's only those expenses that are wholly, reasonably, exclusive, and necessarily incurred in making the profit that will be allowed as deductible expenses. It is not all the expenses. Those ones, have some people left? It's not every. Hello?
You can go on, sir. We can hear you now.
Have some people left?
Hello, sir.
Yeah, some people have left.
You can go on now. You can go on, sir. We can hear you.
Yeah, I'm asking, have some people left?
We have a good number on the call. We have 94 people on the call at the moment.
Oh, 94. Okay. So, Onyikon, can you read that material on so we want to see how has the court interpreted what amounts to wholly, reasonable, and exclusive. So, Onyikon, please, can you read that material for us? How have the court interpreted what amounts to wholly, reasonably, exclusive, and necessary? It is not all expenses that a person incurs that will be deducted against the gross profit. So the first money, when you gather all your profit at the end of the day, that is gross profit. All the money that people pay you, you put in a bucket, that is gross profit. You now deduct your expense. How much did I spend on transportation? How much did I spend on rent? Those people that carry the load for me, my employees, you now deduct those. That's the expenses. Whatever is remaining is now what you get taxed on. But how do you determine those expenses that are taxable, that are deductible? It's not all expenses that is allowed. The expenses that are allowed must meet the rent test, WREN. So how did they interpret the rent? Please, can you read for us when you come?
rent test. Section 10, sub 1 of Petroleum Profit Tax Act, PPTA, which has similar provisions with Section 24, sub 1 of CITA, which is similar to Section 20 of the Personal Income Tax Act, PITA. In Gulf Oil Company Nigeria Limited and FBIR, at 36, the Supreme Court defined the words wholly, exclusively, and necessary to mean the same. The court stated that they can be said to mean solely or entirely. The court further stated that the dictionary meaning of the word necessary is the same as the words inevitably and unquestionably. That means outgoing and expenses that can be deducted must be such that is inevitable or is unquestionable for the successful operation of the company. Similarly,
okay, hold on there. So in Nigeria, the court held that those expenses that are deductible are those that are inevitable or that naturally flow from making profit, that business. So if I'm a lawyer now and I purchase wig and gown, that is inevitable for me to practice law. If I pay my practicing dues to MBA, Nigerian Bar Association, that is inevitable. Okay? If I go for masters in land law, maybe I'm practicing land law, that is good. That is so that I can get more knowledge to practice the law. That's deductible. But if I now go and buy lipstick or go and buy Brazilian hair, I mean, it will be too, I mean, you don't need that. You can, you can just palm your hair and put your wig on it and win your case. So it's not, it might not meet the test. If I go and buy a Rolex wristwatch of 200 million naira, that is not necessary. It's not inevitable. But those things that are inevitable. But if I want to win a contract from an American and I take him to a hotel in a good luncheon for a good meal, that is good because the person will now be much more inclined to say, okay, this person is a good guy. So is it inevitable? Go ahead, Onyekon.
similarly, in Shell Petroleum Development Company and FBIR, the court gave the same meaning to those words. However, the English courts gave a different meaning or definition to these words. They interpreted the word wholly as referring to the amount or quantum of the expenditure, while the word exclusively referred to the purpose or motive of the expenditure. See Bentley Stokes and Lawless and Beeson. The word necessary was interpreted to imply an obligation to incur certain expenditure. See Simpson and Tate, Ricketts and Colloquium. Compare with Mitchell and Child. That's awesome.
Are you done?
Yes, sir.
Okay, sorry, you are breaking. I don't know if I'm the one breaking up or you're the one, but I missed you at a certain point. So the English court did not follow the Nigerian, it's different. The English court did not say that the words mean the same thing. The English court now separated each of the words and gave them, okay, what does wholly mean? What does reasonable mean? What does necessary mean? So the English words separated the words and gave them separate. Take away from section 20 is that the kind of expenses that can be deducted meant to help that business to succeed. If a person is a organizer, the person will buy a pumping machine, a lever, a jack to lift up the car. Those go and buy a laptop. We are not that sophisticated. Then, if a lawyer, if a medical doctor, okay, incurs money, incurs to buy stethoscope, scanning machine, yes, those ones can be. But for him to go and buy an airplane, is he flying to? That may not be necessary. And then if you are talking about reasonable, you compare the expense to what the person is making. A person who's making on purchase something of 30 million, it's not necessary. You have to say is when you get an expense, person spends something, incur an expense, you have to ask yourself, is it only used to produce the income? Okay, all the machine generator in a month, are they used to fund the law of
Yes, sir.
yes. Is there any question before we move on? Hello? Is there any question?
So we lost you at that part when you were saying, and they are used to fund the that. We didn't hear anything anymore.
Okay. I'm saying that if a person purchases diesel of 1 million naira in a month for his law office, and then we find he hosted a party for 5 days, disco party, Owambe party, for his colleague. You know that the money, the expense for the diesel was not only used for the business, may be disregarded. So I'm asking now, is there any question on the deductible expense? Please ask the question before we go on. So section 20 says that any expense that will be deducted must be only reasonably necessary and exclusive use. Out. Do you have any question? I want us to, we have done exempted income. We have done that under section 19 and schedule. So we want to move to gift exemption to income. Gift. If a person gives you a gift, so that before I get logged off, let me be watching so I don't get logged on. Before we get logged off, so Onyekon, please, can you read the facts? Go to page
17.
Yeah, the bottom of page 17. We want to look at the case of Dubenstein. You must know this case, Dubenstein, Commissioner was on Dubenstein. Let's all look at that case from the bottom of page 17. Let's go ahead.
Okay. Commissioner and Dubenstein was a United States Supreme Court case from 1960 dealing with the exclusion of the value of property.
Go to page 18 so that we won't lose time if I get from page.
Okay, sir. Commissioner and Dubenstein. Berman was president of Mohawk Metal Corporation. Dubenstein was president of Dubenstein Iron and Metal Company. They would often talk on the phone and give each other names of potential customers. After receiving some particularly helpful information, Berman decided to give Dubenstein a gift of a Cadillac, sorry. Although Dubenstein said he did not need the car, as he already had a Cadillac and an old mobiles, he eventually accepted it. Mohawk Metal Corporation later deducted the value of the car as a business expense, but Dubenstein did not include the value of the Cadillac in his gross income when he filed his tax return, deeming it a gift. The commissioner asserted a deficiency for the car's value against Dubenstein. The tax court affirmed.
Okay. All right. So before we go off again, in this case, there are two friends, Onyekon and Precious. They were sending themselves business. Onyekon will give business to Precious. Precious will give Onyekon. So after one good deal, Onyekon made 10 million of need this car. I already have the massive Benz. But Onyekon said just give it to her. And then the court, and the taxman now said, oh, you have made profit by getting this car. Onyekon now, the Precious now said no, it was a gift from Onyekon. The issue is this now. If you see, this came out last year. Is there an income? Can you hear me? Hello?
We can hear you now, sir, but you were breaking initially.
Can you hear me? Hello? Can you hear me? Can you hear me?
Sir.
You can hear me?
Sir.
So this came out in exam last year. If you please, can you let me know if you cannot hear me?
We can hear
First
you.
thing you must know is that you must add, yes, you say, is there an income? Yes, there's an income because Dubenstein got what? He got a car valued at 2 million naira. Yes, there's an income. The next thing is this. How do you know there's an income? Under section 3 of Commissioner versus Glenshaw, it says that undeniable accession to which the taxpayer has dominion. So in this case, this person got a vehicle, 2 million. That case latitude. The issue now is this: is it a gift? Why did Bernstein, why did he give the to Bernstein? Why? Because Bernstein is waiting for another business referral in the future. So if Onyekon is a lawyer now and she sends me business, and that house is not a gift too. It is because I want Onyekon to continue to give me business in the future. If you work for your employer and in December they give you a bag of rice, turkey, and groundnut oil, it is not gift too. They want you to go and eat well so that you remember them and you work hard for them next year so they can make more. Can you hear me? Can you hear me? Hello?
Yes, sir, we can hear you.
All right. So please, I need to hear exactly. So the court now said what amounts to the same thing happened in Stanton. Onyeka, please, can you read the case of Stanton for us? Stanton versus United States.
Stanton and United States. Stanton worked for the Trinity Church in New York City.
Have you read it before? Have you read it before?
No, sir, I've not.
Okay, read it now. Yeah, quickly.
Stanton and United States. Stanton worked for the Trinity Church in New York City as the comptroller of the church corporation and president of the corporation. He resigned from both positions to go into business for himself. As a gratuity, the corporation's director awarded Stanton $20,000 in appreciation of the services rendered. While some directors testified that Stanton had been well liked by all in the vestry, and the $20,000 was a gift to show his goodwill, there was also some evidence given that Stanton was being forced to resign. The trial judge made a simple finding that the payments were a gift. Should I read the issues? The issues. Was the car that Dobenstein received a gift for taxation purposes? Was the money that Stanton received a gift for taxation purposes? Holding.
Okay, now
Justice.
we are back.
Okay.
Can you hear me? Can you hear
Yes,
me?
sir.
So
Yes, sir.
everybody, can you hear me? Before a gift can be exempted, it must meet the test at the bottom of page 18. The last two lines. Let's start from there, Onyeko. The last two lines at the bottom of
Gifts results.
The last two lines. Gift results
From detached and disinterested generosity. Dubenstein at 285, quoting Commissioner of Internal Revenue and Low Bill.
Okay. Sorry, you are breaking up. Can you start again?
Okay, sir.
And then to page 19.
Gift result from detached and disinterested generosity.
Oh.
Dubenstein at 285, quoting Commissioner of Internal Revenue and Low Bill. Gifts are often given out of affection.
Gifts are often,
given out of affection, respect.
One, yes.
Respect, admiration, charity, or like impulses. Dubenstein at 285, quoting Robertson and United States. Contrast payments given as involved and intensely interested. See Oak and United States.
We are going to end now. Just hold on. We are going to take it again. So for there to be a gift, can you hear me? Please answer me. Can you hear me?
Yes, sir.
We can hear you, sir.
Okay. For there to be a gift exemption, whatever person gets, it must be detached. That means there must be no underlying.
So your line is
made
breaking.
out of. Yes, I will go over it again. Gifts are often made out of affection. Can you hear me? Can you hear me?
Sir. Yes, sir.
Gifts are often made out of affection, consideration, or charity. If gift is made by people who love you truly, like your grandmother, your dad, your mom, your brother, your uncle, your aunt, not your employer. Can you hear me?
Yes, sir.
Yes, sir.
Can you hear me?
Yes, sir. We can hear you.
Hello? Oh, today's today.
We can hear you,
Can you hear
sir.
me?
We can hear you,
Okay.
sir.
If Onyeka gives me 500,000, is that a hello? If Onyeka gives me 500,000, is that a gift? Can somebody answer me?
Sir, it depends on our intention. It depends on our intention.
If Onyeka gives me 500,000, is that a gift?
It depends on our intention, sir.
If is that a gift?
Yes, sir.
Eh?
No, sir.
Why is it not?
Because she might have an interest in you marking her up because you know that you are a lecturer. So there's something you can do for her.
Okay. She wants to get A, Abby.
Yes.
She wants to get A. Hello?
Yes, there is disinterested generosity there. So that's all.
Yes. What?
I said the generosity is kind of
Yes, what?
somehow. I said the generosity, so we can't say it's a gift. Like from what you said earlier now that
I'm listening. Yes, go ahead.
a disinterested generosity cannot amount to gifts. So we can say that the money or the
Disinterested generosity
was
amounts
supposed
to gift. No, you are wrong, go.
No. I said it is not a gift. Like
Generosity.
since there is
Generosity that has no
disinterested
interest.
generosity there. This man.
I can hear you.
Like what I was trying to say is that Onyekons, the money that Onyekons that 500,000 is not a gift because we can say that, or it be implied that the money is disinterested generosity, so it cannot be a gift.
Okay, Onyeka, let's look at the exception to gift. Exception to gift. Let's look at the case of Wolder, and we end there today. The case of Wolder versus Commissioner Wolder.
Wolder and Commissioner. The United States Court of Appeal for the Second Circuit decided whether gift exemptions, exclusion of bequests from gross income, included those made in consideration for services, and whether the detached and disinterested standard applied to gifts made at that time. Facts. Victor R. Wolder requested Marguerite K. Boyce as her attorney. In a written agreement with Boyce, Wolder agreed to render legal services from time to time as long as both shall live, and not to bill her for such services. In exchange, Boyce promised to make a codicil to her will, giving Wolder stocks or securities from her estate. Wolder provided legal services without billing Boyce, and she revised her will, bequeathing to him $15,845 and 750 shares of stock. Arguments. Wolder argued that bequests received from Boyce were excluded from income under gift exemptions. He believed bequests had been interpreted by the court to include bequests made for considerations between the beneficiary and descendants. In support of his argument, Wolder cited United States and Merriam.
So what I want you to hold out of that one is that where gifts are given based on services performed. This guy was a lawyer. He was helping this client, and the client now gave him gift in a will. That is an exception. It was made in consideration of his legal services, so it is not a something is given to a person. If something is given from Mr. A to Mr. B out of generosity, detached, disinterested, then it is not income. That's an exemption. But however, if a service is being performed If a service is being performed before that gift is made, then the holder exception will come in and say, no, it is not a gift, it is remuneration. However, based on the standard in Duberstein case, the gift must be made out of detached, disinterested generosity based on or like affection, like respect, admiration, love, charity. So if a person retires from Unilag and he was a nice lecturer like Professor Sonny, and we give him a car for your services that you have performed, not something he's going to do for us in the future, then that is a gift. But if he becomes Attorney General and we hope that we are going to use him in the future to get something from the federal government, then we give him something. That is income because we are giving him that gift because of something we want to get from him. Do you have any question? Any question?
Sir, please can you explain it again?
What?
The gift exemption.
Then if the line goes up, you are the one causing it. So if Mr. A gives something to Mr. B, and Mr. A does not expect anything in return from Mr. B, that is a gift. If Mr. A is related to Mr. B, and Mr. A gives something to Mr. B based on their family relationship, that is a gift. If Mr. A gives something to Mr. B, and there's no likelihood that Mr. B can give something back in return, out of respect to, my former boss, I went to US. If your former boss, it was the one who trained you, and then you went to US and you came back and you brought something from US and you gave it to your former boss, that is a gift. But if you are still working for him, that cannot be a gift because you are likely to benefit from that person in the future. You are likely to benefit from the person. So there's an interest. If you give me money now, I'm your lecturer, I've not marked your paper. So that is not a gift because if you give me money, I'm most likely to give you A or B or A plus. But if you have graduated, you have gone away from Unilag, you are not coming back again, and then you just met me and say, Mr. Obayemi, here is 10,000 naira for you. I might take it. Because that might be because, but now it is not. So, but the older exception now says that when gifts are being given for services being performed, that's an exception to gift. So the gift for the gift, this is to come in, be made out of disinterested affection, such as respect, admiration, and all that. Does somebody have any question?
Yes. So I want to ask how the court determines the intention of the gifting party, or is it based solely on the likelihood of the recipients getting something in return for the benefits being accrued to
Does anybody have any question?
involved party? Sir,
Does
can you
anybody have
hear
any
me?
question?
Sir, someone just
Oh,
asked the
that big.
question, sir.
Does anybody have any question? I can't hear anybody.
Can you hear me, sir?
or Debbie.
The lecture has not started.
Bye bye.